Good afternoon. My name is Elena Shaltsova. I am an immigration attorney from Brooklyn, New York. In today's legal speaking video, I would like to talk to you about what to do if now you're in immigration court proceedings, removal proceedings, and you're married to a U.S. citizen. So the plan will depend on whether you can adjust or you cannot adjust, because either United States citizenship and immigration services will have jurisdiction over you if you're not in immigration court and you can adjust. But now when you're in immigration court also can handle adjustment of status for somebody who qualifies if they're in immigration court. So if you can adjust, meaning that you have a legal entry previously or parole, what's going to happen is that the judge will adjourn the case until your I-130 petition to recognize you to be an immediate relative of the U.S. citizen who's sponsoring you is approved by United States USCIS. Because only USCIS, not the immigration judge, can approve that petition, I-130 petition. Because marriage case is a two-step process. First, the I-130 has to be approved, then I-45 and other forms. Ordinary, a person who is not in immigration court will file the whole package together. But when you are in immigration court, you're going to go step by step. So if you can adjust, first I-130 has to be approved. You're likely to be invited for an interview. You have a high burden of proof that the marriage is in fact real, opposed to if you were doing it with USCIS without the immigration court. Okay, but it's possible, it's very much doable. You should be able to handle that. And after I-130 is approved, then you go for adjustment of status with the judge. Previously, lawyers would ask the immigration court to terminate the case against you. So for the second step, you also could go to USCIS. But nowadays, the judges handle the process, and it will be the judge who will decide whether or not to give you a green card. Right? If you are adjustable and if you deserve the adjustment, which usually unless you really do not qualify for it and there are no waivers you can qualify for criminal convictions, you should be able to get. Okay, if you're not adjustable, right, meaning you do not have a legal entry but you are married to a U.S. citizen, you still have a chance. Okay, what's going to happen is this. Previously, lawyers would ask the judge to terminate the proceedings so you can get I-601A waiver and handle the whole case through I-601 waiver. Starting from last year, that practice was terminated by Attorney General. The Attorney General stated that the judges do not have jurisdiction anymore to terminate the case for that. So what's going to happen is that you're either going to perhaps qualify for cancellation or removal, but if not, if you don't have the required qualifications for that, then you can either ask the government to dismiss your case, dismiss the case against you, and that's how the removal proceedings will be closed and you will be able to get I-601 waiver and the whole thing, or you will ask the government to allow you to leave for voluntary departure. And here is a situation that you will still need a waiver to come back, but that's at least with this situation you will not have to apply for one more waiver, a waiver when you receive order of deportation against you, or order of removal, and then you have to fight for that waiver or permission to apply for admission as well. So it will be harder basically to get lawful status in the United States, and it will take longer, but possible. So I hope this video was helpful, and if you need more information regarding the United States immigration process, you can find it on our website www.shaltsova.com.